You've got a mediation date on the calendar, and everyone keeps telling you the same thing. Just be reasonable. Here's what no one tells you. Mediation can decide the outcome of your Florida family law case before a judge ever hears your name. If you walk in unprepared, you don't just risk a bad deal. You risk losing control over your finances, your parenting time, and your future. Today, we're going to show you how mediation actually works in Florida family courts, what the law really says, and how to protect yourself before it's too late. Why is mediation required in Florida? Let's start with the law. Under Chapter 44 of the Florida Statutes and Florida Family Law Rule of Procedure 12.740, courts have broad authority to require mediation in contested family law cases. If you and the other party do not agree on issues like parenting plans and timesharing, child support, alimony, equitable distribution, the judge can, and usually will, order mediation before setting your case for trial. There are limited exceptions, such as certain Title 4D cases, post-judgment contempt proceedings and enforcement, or situations involving domestic violence, from automatic referral. It does not exclude pre-judgment contempt, for example, violation of a temporary relief order. During the divorce and most contested cases, you cannot skip mediation. And how you handle it matters. What is mediation in Florida Family Court? Mediation in Florida is conducted by a court-certified mediator, often an attorney or trained professional, whose job is to help the parties try to reach a voluntary agreement. The mediator is neutral. They do not represent either side. They do not give legal advice. Mediation may be held in person or by Zoom, and the mediator may meet with both parties together or separately, depending on the circumstances of the case. What's critical to understand is this. What happens in mediation can determine whether you resolve your case on your terms or hand control over to a judge. Florida is a non-recommending mediation state. This is where Florida is very different from states like California. Florida is strictly non-recommending mediation jurisdiction. This means the mediator does not make custody or financial recommendations. The mediator does not tell the judge who was reasonable or unreasonable. The mediator does not write a report about what happened in the room. If mediation fails, the mediator files a simple notice stating that the case reached an impasse and nothing more. The judge never hears what was said. Confidentiality. What's said in mediation stays there. Florida mediation is protected by Section 44.405 of the Florida Statutes. Everything said during mediation is confidential, with very narrow exceptions such as threats of violence or new criminal conduct. That means offers can't be used against you later, statements aren't evidence, concessions don't come back to haunt you. If someone violates mediation confidentiality, the court can impose serious sanctions, including attorney's fees. This confidentiality is one of the strongest protections you have, if you understand how to use it properly. How to prepare for mediation in Florida. Preparation is the difference between walking out with control or walking out pressured into a bad deal. First, know what you want and why. In Florida, there is a presumption of equal time sharing and equitable distribution. Walk in with a clear parenting plan proposal and a completed financial affidavit. Second, stay child-focused. When discussing time sharing, tie your position to the best interest factors under Section 61.13, not emotions or fairness arguments. Third, complete your mandatory disclosure under Rule 12.285. You cannot meaningfully mediate if financial information is missing. Fourth, don't take the bait. If the other party gets emotional or accusatory, remember, it stays in mediation. Stay calm, stay solution-focused. What happens if mediation is successful? If you reach an agreement, it must be reduced to a written settlement agreement and signed by both parties. Once filed, that agreement is generally binding. In cases involving children, the judge will still review it for the children's best interests, but courts almost always approve well-prepared, voluntary agreements. What happens if mediation fails? If mediation ends in an impasse, the case proceeds towards trial. Nothing said in mediation is used against you, but you lose the opportunity to resolve the case privately and on your terms. And one important warning. If a party fails to appear at court-ordered mediation without good cause, the court must impose sanctions, which can include paying the other side's mediator and attorney's fees. Here's the bottom line. In Florida Family Court, mediation is not a formality. It's often the most important moment in your case. Handled correctly, it can save you time, money, stress, and protect your children from unnecessary conflict. Handled poorly, it can lock you into outcomes you regret. At Nest Law, we don't just show up to mediation. We prepare, we plan, and we walk in with a strategy. If you're facing mediation in a Florida family law case, visit nestlaw.com and make sure you walk in informed, prepared, and protected.